Sometimes in a domestic violence criminal case, the offer that the prosecution gives you really sucks. Maybe it's a conviction that's going to ruin your professional life. Maybe it's even jail time or prison time. In this video, I'm going to be going through 9 steps that your attorney should take if you got a bad offer from the prosecution. My name is Veronica. I'm an attorney here in California. I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at your restraining order hearing and win. So if that is something you're interested in, make sure that you get your free first class in the description box down below. Okay, so let's jump right in. You got an offer from the prosecution in your domestic violence criminal case and it sucks and you really don't want to take it. What can be done? There are 9 things that your attorney can and should do to get you an offer so you can actually put the case behind you and move on. Number 1, your attorney should have a good reason that they can explain as to why the current offer will not work for you and why you should get a better offer. Now look, nobody wants to go to jail. Nobody wants to be convicted of a crime, right? But if you can show the prosecution why you can't take a conviction, for example, if it will give you trouble with your professional license, or if you are in college and you are about to apply for grad school and it will mess you up there. Or maybe you even just have some future aspiration that this conviction could potentially get in the way of. If your attorney can explain that to the DA and say, look, my client has put in so much time and effort to putting their life on this great track that's going to be great, not just for my client, but for society, and don't screw them up, don't take away their future, that can go a long way. That can be persuasive. With jail or prison, if you have children that you need to take care of, if you have a job that your family needs in order to pay the rent and you're going to lose it if you go to jail or prison. Those are all really good reasons. So your attorney needs to get a good reason. Now, I have had clients in the past who really didn't have any plans for the future. In fact, I had a client where I represented one of 4 co-defendants accused of the same thing. It wasn't a domestic violence case. It was a gang, like assault with a deadly weapon case. And my client, despite having similar criminal history to the other 3 defendants, is the only one who didn't go to prison. He got probation. The reason why? So I asked him, hey, what are your goals for the future? He's a young guy, about 20. What are your goals for the future? What are you planning to do so I can explain to the prosecution why he can't go to prison? And he has none. He's in jail. His bond is really high. So I tell him, okay, I'm going to come back in a week. And when I come back, you need to have some sort of plan for the future, something that I can sell to the prosecution. And I gave him some suggestions. I talked to him for a little bit. I came back in a week. Okay, he's going to go to school to become an electrician. And so I talked to the DA supervisor, I talked to the DA, and I explained, you know what, all of his hopes and dreams are in being an electrician. He wants to get out of this lifestyle. And so he got probation on the condition that he goes to school and becomes an electrician. So everybody else went to prison, and he actually was forced to make good on that dream and become an electrician. It was interesting at sentencing. The other defendants are obviously jealous of my client because they're all getting shipped off to state prison and he's getting released. And the other defense attorneys were asking the DA, how come he gets probation and my client goes to prison? And the DA said, nobody else asked to go to school. Number 2, file motions even if there's a low chance of success or if the outcome doesn't necessarily matter. Look, just like the public defender, the DA is extremely busy. They usually have about as many cases as the public defender has, if not more. If they know that if your case keeps going, they're going to have to respond to those motions, then that gives them a little bit of incentive to get rid of your case. Okay, I'm going to have to respond to 2 motions here. I'm going to have to spend the time, even if I don't think that there's a great chance of success. I have to explain to the court why the motion should be denied. I'm going to have to spend all that time doing that research, type it out. What can I do to get rid of this case? What does the defendant want? Is it that unreasonable? Maybe I can just get rid of this case altogether and never have to respond. Sometimes I have clients who, when the police first come out, they ask my client questions or my client makes statements that are not good, that I would rather have thrown out. Maybe not exactly a confession, but incriminating statements, right? And the client was not Mirandized, so was not read his rights, and then gets taken into custody, into jail, and now is read his rights and makes the same statements and confesses. If the client was Mirandized and waives his Miranda rights knowingly, intelligently, then that confession, the second time that the client spoke is probably going to come in. Does it make a difference if we get rid of the statements that the client made the first time? If you went to domestic violence classes, go to anger management. It is worth it because it gives your attorney some ammunition to say, okay, that was your offer with my original character packet, but now I have an even stronger one. Look, he's gone to 10 more hours of anger management. What more do you want here? He's doing everything that he possibly can, just wants to put this case behind him. That can be very persuasive. Number 4, be patient. When you have a criminal case, you want it to be just done with. You want to get it over with. You're always wondering, when is this thing going to be over? Because it fills you with a sense of anxiety, dread, wondering what's going to happen, right? But be patient, keep coming back to court, and your attorney has to be willing to keep coming back to court. The judges in California do not want cases to get super old, because if cases are getting old, that means that there are more and more cases stacking up, and soon the court will not be able to hear all the cases, right? So the judges are told by the chief judges, get these cases done within a certain amount of time. And if you want your case to get older than that, you usually have to have a good reason. How long you have, it really depends on the court, depends on the judge, depends on how busy they are. But since there is generally a time limit for how long the judge will let the case just stick around with plea negotiations before setting it for trial, what your attorney needs to be willing to do is to keep coming back for court. I've had cases where I come back every week because what I'm trying to do is be the squeaky wheel, to keep coming back. So now they actually are paying attention to my case. They remember my case, they remember my face, remember my client's face. And every time I'm there, I'm explaining why I need a better offer. I'm turning in more mitigation. I'm filing another motion. I'm doing more and more. So sometimes the DA is like, okay, what do you want? I will talk to my supervisor for you. I will try to get you a better offer. They see that you really care about the client. They see that you are not just going to back down. They can see that the client cares about their own life. And sometimes that is enough to tip the scales in your favor. Number 5, as a defendant, sometimes it can help when you show up to court, even when you don't have to, even when you have court permission for the attorney to appear for you, and make a good impression. Be friendly, be well dressed. Even if you're waiting a long time, maintain a pleasant expression and demeanor. The DA will start to remember you, and if you show up friendly, clean, looking professional, looking well dressed, then the DA now can put a face to the name with your character packet, can see, oh, this is the guy who's doing a crazy amount of anger management and domestic violence classes. What does he want again? And that can sometimes make all the difference. Number 6, depending on the county, your attorney can have a DA supervisor meeting. This is where your attorney sets up a meeting with a higher ranked DA and asks for a better offer. This isn't being a Karen or anything like that. Basically, the DAs on the case only have so much power. They can't, for example, just decide to dismiss all the cases. They need to follow their supervisor's instructions. But the supervisor does have more power. So if you want a better deal, sometimes going to the DA supervisor is the way to get it. Number 7, if the issue isn't that you want to keep your record clean, it's more of an issue of jail or prison time, then you can ask the judge for an offer. Now, the thing about asking the judge for an offer is the judge can reduce felonies to misdemeanors if they're wobblers, like PC 273.5A, domestic violence in California, but the judge cannot generally just dismiss any counts. So if you were charged with 5 different things and the judge offers you probation, you would have to plead guilty or no contest to all of them. But if you just have PC 273.5A and maybe it's your second time, or there was a bad injury, or maybe you have a record for some other crime, or you've been to prison, and your concern is more that you don't want jail time or prison time, then your attorney can meet with the judge and the DA, often in chambers, present all your mitigation, make their pitch as to why you should get a better offer and get an offer from the judge that can sometimes be much better. Number 8, point out flaws in the case and inconsistencies that the DA might not be aware of. Okay, so the DAs have big stacks of cases, and sometimes there's a different DA every single time you go to court, or many times when you go to court, and so they may not be aware of problems with their case. They probably haven't watched any of the video in the case. They probably just read the police report. So if your attorney can point out flaws in the case and inconsistencies to the DA, is this one that you actually want to take to trial as a DA? Because if it's a weak case, maybe they don't want to. Number 9, set the case for trial. Call their bluff. Be willing to take it to trial. Sometimes on the eve of trial, during jury selection, now maybe the DA is actually looking at the case more, and trial is an extremely large time commitment for them. you might get a better deal. Now, on the other hand, whatever offer they were giving you probably will expire if you set it for trial, or for a felony case if you have a preliminary hearing halfway through. But if it's going to cause you really to lose your job, or it's going to mess up your future, they're not giving you much of a choice. Especially if there are problems with their case, you might want to just set it for trial. I hope you found this video helpful. Remember, if you have a restraining order, make sure you get your free class on how to win your case via the link down below. If you have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.